HB Media Minute, a podcast from Haynes & Boone that focuses on legal trends impacting the media and entertainment industry, intellectual property and First Amendment law. I'm Nathan Koppel, the Director of Media Relations for Haynes & Boone, and today we're going to talk about some interesting and significant developments in anti-SLAPP protections in the European Union. Up until now, the EU has had no express protections from SLAPP suits, and as most of our listeners are aware, SLAPP is an acronym that stands for Strategic Lawsuits Against Public Participation, which are a prevalent form of judicial harassment. The EU is waking up to the dangers of SLAPP suits, as we'll talk about today. The European Commission has issued a proposed anti-SLAPP directive, which requires member states to achieve certain target goals without dictating how the member states are to achieve these objectives. We're going to explore the directive and related topics today with our two guests. Laura Prather, the head of Haynes & Boone's Media and Entertainment Practice Group, will interview Charlie Holt, the founder and co-chair of the Coalition Against SLAPPs in Europe. They're going to talk about the developments in implementing protections against SLAPP suits in Europe and how we got here. Laura is an experienced trial and appellate lawyer who has litigated against SLAPPs in courts across the country and has advocated for and been instrumental in the passage of anti-SLAPP laws throughout the U.S. She recently returned from a stint as a Fulbright scholar, studying global freedom of expression issues. Charlie serves as legal counsel for campaigns for Greenpeace International and UK campaigns manager for English Pen. He has a strong background in human rights advocacy and a thematic expertise in freedom of expression and the right to protest. Charlie was instrumental in establishing the Coalition Against SLAPPs in Europe and the UK Anti-SLAPP Coalition, and has personal experience through his work at Greenpeace in the devastating impact SLAPP suits can have on NGOs, protesters, and others who speak truth to power. So before we get started, our disclaimer: this podcast is for informational purposes only. It's not intended to be legal advice and does not establish an attorney-client relationship. The topics we're going to talk about are subject to change. Legal advice of any nature should be sought from your legal counsel. And with that, I will turn it over to Laura and Charlie.
Thanks, Nathan. Charlie, welcome to the HB Media Minute. We are so thrilled to have you here today. Let's start by talking about SLAPPs, Strategic Lawsuits Against Public Participation, and how you first became aware of them.
Thank you, Laura. It's a real pleasure to be here this afternoon, or rather this morning, your end. I first got involved in SLAPPs having been, or having worked for an organization that was frequently on the receiving end of them. I joined Greenpeace International in 2015. And at that point, we already had a number of SLAPPs pending against us, lawsuits that we could confidently characterize as SLAPPs based on certain abusive features that were quite clear. But in 2016 and then in 2017, Greenpeace International was itself targeted by two successive SLAPPs, both of which had a number of common qualities. They were both invoking RICO, the Racketeer Influenced and Corrupt Organization Act, and both of them were filed against us by the same lawyer and the same law firm. They were very much following a similar template. And there are a number of things about these lawsuits that really represented a very different threat, a much more serious threat. For one thing, huge amounts of money were clearly being poured into them. And they were, I think one thing that was quite striking about them was how shameless they were in advancing quite absurd legal theories and factual patterns. The first lawsuit, for example, against us started with the line, "Greenpeace is a global fraud." So these were lawsuits that we had to take very seriously. We also recognized pretty quickly that they were lawsuits, or that SLAPPs really needed a collective response from civil society. There was a number of reasons for those. But one thing that we quickly realized, though, is that a legal strategy is not enough on its own. Since these lawsuits are generally baseless, and since they are generally more interested in the litigation process than in the outcome of the lawsuits, we realized that it's not enough simply to defeat the lawsuits in court. We needed to ensure that they backfired and were seen to backfire, and that they could no longer be considered a viable business tactic. And in order to do that, we really needed to have a collective response. And really, the second lawsuit against us, which was filed by Energy Transfer Partners, the owner and operator of the Dakota Access Pipeline, was really represented a more transparent attack on civil society as a whole. It named a number of other organizations and was, by invoking RICO, clearly an attempt to criminalize all sorts of classic advocacy activity. And that really galvanized civil society in the US. So we were able at that point to set up a coalition in the US, the Protect the Protest Coalition, co-founded by a number of other groups. And at that point, really, we started pursuing a proactive anti-SLAPP strategy, a SLAPP resilience strategy, rather than simply responding to these lawsuits in a reactive capacity.
And that coalition building is hugely important, as you've mentioned, and I want to follow up on that. But let me ask you something first with regard to the jurisdictions in which SLAPP lawsuits are filed. We've talked about anti-SLAPP laws a bit before on this podcast, and the fact that the first anti-SLAPP law was passed back in 1989 in Washington state, but since then there have been 34 states and the District of Columbia that provide some form of anti-SLAPP protection. Back in 2020, in the heart of the pandemic, the Uniform Law Commission came out with a model anti-SLAPP law, and that's become law in 5 states, and most recently was passed out of the New Jersey legislature just last week and is waiting on the governor's signature there. Given the legislative landscape and these 2 examples that you provided that Greenpeace was involved in, are SLAPP suits just an American phenomenon, or is there a broader concern that other jurisdictions are now waking up to?
I think we can say quite categorically at this point that SLAPPs are a global phenomenon, and more so the growth in SLAPPs is something that we've seen all over the world. When we started working on SLAPPs proactively in 2016 on building this anti-SLAPP strategy, obviously the focus was in the US, but we noticed that there was a comparative lack of research in other parts of the world. And so that was something we really were keen to address. And that's why in 2019, when we shifted our focus to Europe, the first thing we did was to start mapping out SLAPPs in Europe. So we worked together with the University of Amsterdam Law Clinic to start mapping out and analyzing the problem of SLAPPs in Europe. That research has now been published by the Coalition Against SLAPPs in Europe. You can find it on our website. And it examines 570 cases over a 10-year period and very clearly shows a growth, a year-by-year growth in those SLAPPs. I think one thing we've really found as we've started looking at individual countries in Europe is that you often find that there's a complacent assumption in many countries that SLAPPs is not a problem there simply because they haven't been reported on or they haven't actually been tracked. So there haven't been any research. And of course, in the US, it was really the research of George Pring and Penelope Kanan in the 1980s that really led to the formation, the passage of anti-SLAPP laws in the US. And I think we're seeing something similar in Europe, that now that we've started to really cast a light on the problem, decision makers are starting to take seriously the problem and explore potential solutions. And I think what we're starting to see now is outside of Europe, similarly, people are starting to really examine and explore this problem and research it. And as a result, we've seen anti-SLAPP coalitions, for example, being set up in Africa. So the Coalition Against SLAPPs in Africa, I believe, has recently been set up after following a coalition in South Africa called Asina Loiko. Likewise, in places like Thailand and India, there's been a lot of examination of the SLAPP problem. But as I say, in countries we see in Europe, it's only been where research projects have been undertaken that people have really started to appreciate the scale of SLAPPs. I think this is something similar in the UK, where there's very clearly been a problem with SLAPS for a while, but it's only really been in the last couple of years when groups such as the Foreign Policy Centre started researching the problem and looking into it, that decision makers started taking this seriously.
Let's back up just a little bit, because that research started after there was really a wake-up call in the EU. Tell us about Daphne Caruana Galizia and that wake-up call about SLAPP suits in the EU. What prompted the government to finally realize something needed to be done?
Yeah, absolutely. Daphne Caruana Galizia was a Maltese investigative reporter. She was once described as a one-woman WikiLeaks. She was incredibly influential and well-respected across Europe. And she was assassinated at the end of 2017, which was it was a huge shock, of course, to many across the continent, and I think really shook up many people's complacency about the state of press freedom in Europe. At the time of her death, she had 47 libel lawsuits pending against her, and many of these lawsuits ended up shifting to the children, the family of Daphne Caruana Galizia when she died. And they were filed by a number of members of the Maltese political elite, all sorts of politicians, including the then Prime Minister. When she died, that really cast a spotlight on the problem of SLAPS in Malta, but also in Europe more broadly. And that was partly as a result of the fact that a number of the legal threats that had been issued against her had been issued in the UK. In fact, one of the lawsuits that was filed against her was actually filed in Arizona. So there was really this is a problem that stretched all over the place. And as a result, a number of people started to recognize that when we're talking about SLAPS, this wasn't just a US problem. It was a problem that was severely impeding the work of journalists, but more broadly, activists, NGOs, whistleblowers, and so on across the continent. And as a result, a number of press freedom groups after the death of Daphne Caruana Galizia came together, and they started working to explore potential EU-wide solutions to the problem. And it was this group of press freedom groups that really, when we set creating the Coalition Against SLAPS in Europe, this was really the foundation of those efforts, particularly in the advocacy field.
So I kind of refer to you as the father of the Coalition Against SLAPS in Europe, because I attribute this organization to your wonderful advocacy skills. At this point in time, this Coalition Against SLAPS in Europe, you mentioned it started as just press freedom organizations, but now it's far broader than that. Is that right?
That's absolutely correct. Yeah. CASE includes members representing a range of different public watchdogs. And by public watchdog, we mean anyone who works to expose wrongdoing or hold the powerful to account. And of course, that can encompass all sorts. It can encompass citizen journalists, or those who have blogs, or who are simply, setting up a Facebook group to expose corporate wrongdoing, for example. So we really try to represent everyone who is targeted by SLAPS. And as a result, in our coalition, we have members who represent activists, whistleblowers, academics, NGOs, and so on. And also a range of different subject matters. So, we see groups who are working in the field of anti-corruption or democracy, as well as environmental groups such as our own, and then, of course, press freedom groups. So it's a very wide-reaching coalition. And I think one thing that's been quite interesting as CASE has been developing and growing is that we see SLAPS manifesting in very different ways in different jurisdictions. And within CASE, we have members who stretch from Georgia in the east, through to Portugal and Spain in the west. It's a very wide-reaching coalition on that, and so there are all sorts of different features and that we have become familiar with, and that I think really does help our advocacy efforts as well.
And tell us again, what is the website for CASE? And I know that you've already mentioned that it includes the wonderful research of the mapping of SLAPs SLAPs across Europe. Tell us a little bit more about the resources that are provided on this website for folks, and then we'll get into a discussion about what the government's doing to clamp down on SLAPs.
Sure. So the website is www.the-case.eu. And the website was launched in 2021, about a year after advocacy groups across Europe first came together to discuss anti-SLAP resilience and to form the foundations of CASE. So we've been active now for about 3 years. And following the meeting, the conference that brought us all together in February of 2020, we set up 3 different working groups. And the work of those working groups is reflected in the website or can be found there. So the three working groups, one focuses on advocacy, who explores ways that we can together advance anti-SLAP solutions on an EU level, and we'll talk about that later on, but also more widely in relation to the Council of Europe. I think we'll talk about that as well. But we also then have a legal working group, which works to build legal resilience of public watchdogs, and a campaign working group, which seeks to expose SLAPs and those who use it, to delegitimize SLAPs as a means of responding to criticism, and really just to raise awareness. And the website is a place where we're able to, all of the various projects we're working on, you can find more details about them there. And like you say, we have a number of resources for public watchdogs and for those who are targeted by SLAPs to use, including a growing legal network, a network of lawyers and legal services who are able to assist those targeted by SLAPs.
That's fantastic. And so within the group, the CASE Coalition, I know that this particular group was extremely instrumental in getting the European Commission to actually issue the anti-SLAP directive that it publicized on April 27th, 2022. Can you tell us a little bit about what the European Commission anti-SLAP directive, what it said, and whether it has any legal binding effect on the member states or the EU at large?
Yeah, absolutely. So the draft law that was published in the beginning of April 2022 is what's called a directive. EU laws come in 2 different forms. There are regulations and directives. And while regulations are directly applicable, regulations establish minimum standards. So they are essentially guidelines, certain standards that have to be met by the member states. But exactly how that's transposed into law on a national level is left to the member states to determine. But I think it's important to emphasize that the directive is legally binding, and it's therefore a hugely significant step in terms of advancing anti-SLAP measures across Europe. If passed, this would then mean that every member of the European Union, each 27 member state, would be legally obligated to then pass their own national anti-SLAP laws. And that would be an anti-SLAP laws that would have to meet these standards. So that's what the directive, the proposed directive is. And yes, like you said, it does have legally a binding effect. It was, as you said, issued or rather proposed in April 2022. It was part of an anti-SLAP package that also included a recommendation. Recommendation was not legally binding, but went a lot further. It was much stronger in many ways in saying what member states should do. So, for example, it also referred to deontological rules, i.e., legal ethics, legal ethical standards. It also referred to things such as legal aid, but it wasn't legally binding. The Commission's directive is it's a very interesting document. I think those of your listeners who are familiar with anti-SLAP laws in the US will recognize many components in it. So, for example, it includes provision for an early dismissal mechanism. it also includes provisions for sanctions and for compensation. So it covers quite a lot, but it is also in many ways a sort of quite a novel approach. It's in many ways weaker than the anti-SLAPP laws you see in the US, since it separates, it creates a dichotomy between those cases, those SLAPPs which are called manifestly unfounded lawsuits targeting public participation. And those manifestly unfounded lawsuits are subject to this early dismissal mechanism, but they're not subject to the various protective remedies, the various things such as sanctions and compensatory damages that abusive proceedings are. So there's two separate categories there. And that was something that we quite early on singled out for criticism, and we said that this needs to be strengthened. But in many other ways, it really, I think, would establish some very robust measures. As I said, in terms of sanctions, it has provisions, for example, for dissuasive sanctions, proportionate and dissuasive sanctions against those who use SLAPPs, recognizing the need for deterrence. And that is obviously very important.
Charlie, you mentioned abusive features of SLAPP suits. What are those? Give us just some examples of what those abusive features are.
So in the European Commission's draft directive, they identify 3 different features of abusive lawsuits. They are indications of an abusive purpose, an improper purpose. So SLAPPs are generally defined with reference to the purpose of the filer, being a purpose other than that of vindicating reputation, redressing harm. But of course, in order to be able to identify and infer that purpose, it's necessary for there to be for the courts to be able to identify certain features. The Commission has identified 3 of them. Those include the disproportionate, excessive, or unreasonable nature of the claim, the existence of multiple proceedings initiated by the claimant, and then general intimidation, harassments, or threats within that process. Now, I should say that this is quite limiting. In the UK, for example, we've identified numerous different other features that we often see, or which are indicative of an improper purpose. And I think this is something we'll talk about potentially later on. I won't go into detail now. We're at a stage now where the European Council, which is a separate institution of the EU, has proposed a separate document which has watered down in a very problematic way many of the provisions in that directive.
That actually leads right into my next question, which is explaining to the listeners, especially those who have not taken an international law class, how this works. So you've got the European Commission, who has issued a proposed anti-SLAPP directive, and then you've got 2 different bodies, the European Council and the European Parliament. And how do they work together? I'm going to liken it, and somewhat crudely, I guess, to our Congress and our U.S. Senate. How do they work together to ultimately create a law that would apply presumably across the EU 27 member states? And is it similar to our system where there are cases that are filed in federal court that are brought based on diversity jurisdiction and federal claims? Or how does that work? How does this overarching law both get passed and then apply?
Yes, it's a bit confusing. So I think it's good to just break it down. I wouldn't expect your listeners to know about the intricacies of the European Union. I studied EU law as part of my law degree, and I still don't really understand much of it. So it can be quite complicated. But very roughly, just to give just a brief overview of the way the EU works, the EU is made up of 3 co-legislators. So 3 separate different institutions. And I think your comparison with the US Congress is an apt one, because you need to, in order for laws to pass, there has to be agreement particularly between the European Parliament and the European Council. The third institution is the European Commission, and the European Commission is a bit like this sort of EU civil service, but it's different in the way that the European Commission has responsibility for drafting and proposing laws. And it's made up of EU commissioners. The EU commissioners are sort of like experts in their field. They're appointed by member states based on their expertise in a particular field. So the Commission started this process by drafting this draft law and proposing it. That then was examined in what's called readings by the two other co-legislators, which is the European Council and the European Parliament. The European Parliament is made up of directly elected members from across Europe. So they're directly elected by European citizens. And the European Council is made up of representatives of the different governments. So it's made up of different ministers from across the EU, the 27 member states. So that's the difference between them. They separately then examined this law, and they separately then came up with their own different amended versions. So they took the Commission's and they added amendments, so they're slightly different. And the challenge we're at now is that the three institutions have to reach an agreement about a final text. And in this case, the Commission really acts as a sort of mediator between the two, with the Parliament and the Council starting from their different initial texts. So what we've had most recently is a report passed by one of the committees in the European Parliament with their final draft report, their final version with incorporating certain amendments. That is, we're a few days away from that being formally voted on in the plenary of the European Parliament. Meanwhile, the European Council has agreed what is called its general approach. And its general approach is essentially a sort of opening position, opening negotiation position. It sketches out what they see as being the parameters of their own negotiation. And what we will have then, unless one of the two institutions then adopts the other one without question, which is not unlikely to happen, what you then have is we enter a period of what's called trialogues, so three-way negotiation, essentially, between the three institutions to try and find common ground. And as with the US, we're ultimately looking for a harmonized text, which can then be agreed on and voted on together.
Tell us a bit about the European Council's draft and the European Parliament's drafts, now that they're both out, and the key differences and similarities between those drafts that will be part of the discussion moving forward in the trilogues.
Sure. There are a number of problematic parts of the general approach taken by the European Council. But I think there are three things in particular which have really worked to water down the European Commission's proposed directive. So the first of those is something I've already referred to, which is the definition of cross-border. The European Council's general approach strikes out the broad definition given to cross-border, leaving the more formalistic notion of cross-border cases, which the EU has traditionally adopted. So in other words, cases which involve parties domiciled in different jurisdictions. The second thing is the compensation of damages, which the European Commission's directive provides for. And again, the European Council's general approach strikes out in its entirety. So it no longer provides for the victim of slaps to be able to claim damages for the harm caused to them. The third thing that I think is really important to note is that the European Council's general approach adopts a more restrictive definition of manifestly unfounded. So the European Commission directive provides that any case targeting acts of public participation, which is, quote, manifestly unfounded, should be subject to an early dismissal mechanism. The question, of course, is what is a manifestly unfounded case? The European Commission's directive doesn't define that, so it would therefore be left to the courts of the member states to interpret that, and they would do so in line with their own case law. Now, we in Case had argued for a stronger definition of manifestly unfounded, a broader definition. In fact, we argued that those words manifestly unfounded should be removed altogether and substituted for a higher threshold that those targeting acts of public participation would need to reach. What the European Council has done is the opposite. So they've adopted a very restrictive definition of manifestly unfounded. So to the European Council, manifestly unfounded means a case which is so obviously unfounded as to leave no room for any reasonable doubt or any scope for doubt. Now, that is such an impossibly high threshold to meet that in practice it would mean that no case or very few cases would actually be able to meet that hurdle and to therefore be disposed of pre-trial. And that's enormously concerning, because if the European Council's general approach were to prevail, it would render the instrument as good as useless.
So did the European Parliament do any better?
Yeah, so the European Parliament hasn't done what we recommended, which is, as I said, to substitute that test. But they haven't made that definition stronger. So in that case, the European Parliament's test is more similar to that of the European Commission. What I would say about this, which is important, is to think about what I said before, which is that this is setting a series of a set of minimum standards that national governments have to meet. So in this case, it really is a matter where no definition is infinitely better than a very bad definition. Because with no definition, that's then left to the national member states to flesh out. So it leaves room for a more robust anti-SLAPP law to be introduced on a national level. Now, if you've got a minimum standard which is fixing that definition of manifestly unfounded at an impossibly high level, or high for the defendant rather, then that means that these national laws, these 27 national laws, will by default be pretty unworkable.
And going back to the question of what ultimately passes, how do we know where that will apply? For instance, if a corporation sues a journalist in France and that corporation is based in France, would this apply, or would there have to be a change in French law?
Yeah. Okay. So what will happen when this is passed is that EU member states will then draft and pass their own anti-SLAPP laws. And what they're legally obligated to do is to ensure that law complies with the directive. But the directive establishes certain minimum standards, and there are various provisions in the directive which makes clear that how that is drafted into law will depend on the legal systems and the laws in that country. So they'll all take very different forms, but they'll all be expected to comply with these minimum standards. So that's why we're pushing for the directive to be as robust as possible, is because we're not just fighting for one law here, we're essentially fighting for 27 laws. And so I think that's an important thing to emphasize. Just to answer your specific question, though, about the jurisdiction, one thing that is quite controversial, I think, in both ways about the directive is in its scope. So the directive is drafted under Article 81 of the Lisbon Treaty, and the Lisbon Treaty is the European Union treaty which regulates the functioning of the EU, the way it operates, and deals with things such as competence. And Article 81 gives the EU competence to develop judicial cooperation in civil matters, so to develop laws which harmonizes civil law matters, but only in civil matters that have cross-border implications. So the question then is, well, what do we mean by cross-border implications? And with one thing that the European Commission did, which was a very positive development, was that it defined cross-border in quite a broad manner. So it talked about where the subject matter of the lawsuit had relevance to more than one jurisdiction, that would constitute cross-border constitute a cross-border implication. What the European Council has done in its general approach is to strike out this broad definition. They haven't replaced that broad definition with anything, but the fear is that in the absence of any definition, member states will simply defer to the standard traditional understanding of cross-border, which is just, two parties who are domiciled in different EU jurisdictions, which of course would be incredibly limiting. And to go to your example, Laura, it would then only be applicable, the national law in France, if that company that was in France was targeting someone who was outside of France. And to give you some illustration of how limited that is, the cases I spoke to earlier that were mapped out across Europe, only 10% of those were cross-border under this very limited understanding of the word.
So that particular issue of how cross-border is defined, or if it is defined in the ultimate law that is passed, is a significant issue moving forward.
Absolutely. Yeah, absolutely.
So it sounds like right now we are on the cusp of having something passed in the EU that would be an overarching anti-SLAPP law. What the contours of that law look like are a little bit up in the air because it depends on these trialogue negotiations, but the hope is those get done by the end of the year. And then after those negotiations get done, that's when the member states start to work on their own national anti-SLAPP laws. Is that right?
Yes, that's correct. Yeah, once this is all finished and we voted on and agreed, then it will be left to the national member states to pass their own laws.
If a listener wanted to get involved, how would they do so?
They would be very warmly welcome, and we would love more people to get involved. You can get in touch with us at on the website www.the-case.eu, and there's an opportunity. There are contact details there for us. In fact, I think you can contact us at info@the-case.eu or contact@the-case.eu. But there are other opportunities to get involved there too. If you're an advocacy group based in Europe, then that is where we would love to have you on board and working on the working groups. But also just general legal expertise is something that we're really after. I mentioned before that we're building a legal community, a community of lawyers who work on SLAPPs and who defend public watchdogs, and that's something we're really keen to keep growing. And I think that is a community where we're working to exchange information, skills, and knowledge to ensure that we're able to build the capacity of lawyers who are working on SLAPPs.
At this point in time, once the trialogue discussions begin, does CASE have any involvement in that process moving forward?
So during the trialogues, CASE will be continuing to work and will be continuing to advocate throughout this whole process. So during the trialogue stage, we will be putting pressure on national governments to soften their position and to try and shift them closer to the position of the European Parliament. That's something we're going to be really trying to engage in vigorously over the course of the next few months. Now, following the final agreed anti-SLAPP law and the passage of that directive at the end of the year, we will still be working, we'll still be advocating. At that point, we will shift our attention to the national governments and to the national anti-SLAPP laws that will be passed in the transposition process. And we'll be then continuing our advocacy to ensure that those laws on an individual level are as robust as possible.
Is there a time limit for this process?
We're expecting this to all be wrapped up by the end of the year. But there at this stage, aren't any formal time limits. What we know in terms of it is that trialogues are due to begin on the 12th of July, so next week. So this is all very, very, very hot stuff.
An exciting time to be in Europe, for sure.
Absolutely.
And it sounds like y'all are doing a fantastic job with the Coalition Against SLAPS in Europe. I appreciate so much the hard work that you've done and that the entire CASE Coalition has done in this area. Today, you've not only given us some insights into what's going on in the EU, but a little primer on international law, and I think done a very good job of explaining that SLAPP suits are a threat to global freedom of expression issues. So I'm hoping in the future you can come back and we can talk more about what's happening on a global level with the Coalition Against SLAPS in Africa and Thailand and India and elsewhere. But for now, thank you. Thank you for being here and for being a part of our podcast.
Thank you so much, Laura. It's been a pleasure.
I'm going to jump in. And again, Charlie, thank you. And Laura, really appreciate that fascinating discussion. For more on the European anti-SLAPP efforts, check out the Haynes and Boone website, where you'll find an article written by Laura in the November 2022 Haynes and Boone Media and Entertainment Year in Review newsletter on global developments and freedom of expression. And as Charlie discussed, the Coalition Against SLAPS in Europe website is a great resource. That can be found at the-case, that's THE-CASE.eu, where you'll find case research and views on SLAPS in Europe, what the governments and the EU should do to address them, and how to identify SLAPP suits, along with the mapping that Charlie discussed of SLAPS in Europe, along with more valuable information about this phenomenon. Thanks again for listening. We'll be back soon with another episode of HB Media Minute.